session.
Thank you all. Please be seated. Good morning. This is the time set for oral argument in Jackson Wynn and Trin Ta versus American Commerce Insurance Company, our case number CV120862. Each side is allotted 20 minutes for your argument. Appellant may reserve a portion of that time if you choose to do so. Please, if you want to do so, you'll need to keep track of your own time, and there is a clock at the podium. Out of respect for counsel, I would ask that everyone in attendance please make sure that your phones are turned off so our arguments are not interrupted. We have read the briefs. We've conferenced the case this morning. We'd encourage you to keep that in mind as you present argument today. Our proceedings are being recorded and will be posted to YouTube. So please, as you begin your argument, state your name and the party that you represent. With that, Mr. Langerman.
Good morning, Your Honors. My name is Richard Langerman. On behalf of the appellants, I'd like to reserve 3 minutes of my time for rebuttal. This was a hard-fought trial, and ordinarily we wouldn't ask you to look at it, except for there were a few legal rulings that call into question whether it was a fair trial. The jury's determination can only be sound if they are properly instructed and properly given evidence. In this case, there were 2 jury instructions that were missing. The defendant sought rescission based on alleged misrepresentations at the time the insurance was purchased. In order to be entitled to rescission, which would void the contract from the beginning, an insurance company must refund the premiums that it has earned while the policy was enforced because it's not entitled to them if the contract is voided. We all agree that's the law. There's a case from this court back in 1986. We offered an instruction on that issue. It was supported by the evidence. It was a correct statement of the law. And it is reversible error for a trial court to fail to instruct on a legal theory that is supported by the evidence. There was also a dispute.
Counsel, let me ask you, that's plaintiff's 4. That
Yes.
was not given, was based on a decision in Arizona, and then you cited an Oklahoma case from kind of a long time ago. And it dealt with expressly rescission, that if you're going to seek rescission, you need to tender back any benefit that you've received. What was, and having looked at the briefs and the record, was defendant's position that they were rescinding or that they were canceling it on the anniversary of the policy date?
The issue identified in the pretrial was rescission. The issue given to the jury based on a jury instruction requested by the defendant, which was defendant's requested number 4, is a party seeking rescission must establish, and then it lists the elements from ARS section 20-1109. The jury was instructed that the defendant was seeking rescission. The defendant's insurance expert testified that in order for rescission to happen, these things must happen. And then counsel for defendant argued it to the jury. There was no doubt that that was one of the issues in the case. You are correct, Your Honor, that they also then tried to throw up a smokescreen by saying we just canceled the policy and therefore we were entitled to earn the premium till the last date. But that was not the issue presented to the jury.
So
And
the issue of cancellation, jury heard no evidence of that.
No, there was a letter in the claim file that said cancellation. So there was we can say there was disputed evidence. But what the defendant requested from the pretrial to the jury instructions to the evidence to the argument, all of that was we are entitled to rescission.
Remind me, please, what
basis the trial court gave, if any, in refusing that instruction?
I think ultimately the defendant argued that it wasn't supported by the evidence. I think she might have said that, but that was not factually correct. And defendant also argued that it was covered by the general rescission instruction, that in order to be entitled to rescission, you have to prove, and then listing the elements from the statute, which we all agreed should be given. But it wasn't covered by that because that instruction doesn't say anything about, oh, and if you're going to void the contract from the beginning, you're not entitled to keep the money, you got to give it back. Your conduct is contrary to that, and therefore the jury could consider that as they acted inconsistently, and that kind of calls into question everything they did. And the same thing goes with respect to our other requested jury instruction number. Well, it didn't have a number. It was Raji contract instruction number 26.
Except there, I guess the judge commented that she was giving 25 and the subject was more or less covered by that one.
And she did say that, and those two instructions point in different directions about different things, so she didn't cover it. She covered something else, something which frankly I don't even think was relevant to the lawsuit.
In 25, Raji.
Correct.
25.
But one of the key issues in the case was, did defendant convince the jury that it was appropriate to not pay the claim because the plaintiffs had failed in their burden of proving ownership? How does ownership come into this? That word actually isn't in the policy. It's not a policy term in terms of the express terms. It was an implied term because ARS section 20-1105 creates that requirement. And since the policy says we have to comply with Arizona law, and whether it said it or not, they would, technically that is now a term of the policy. In interpreting the terms of the policy, the court in Darner told us that we can look beyond the words in the policy to the words are surrounding circumstances. In this case, as in Darner, the agent represented to the applicant/insured, in order to get coverage for a piece of jewelry, you need to give us an appraisal. And if you give us an appraisal, we can and will place the coverage. It is undisputed that that representation was made. It is undisputed that Mr. Nguyen relied on that representation. In March of 2008, he submitted appraisals on 2 Rolex watches. The company placed insurance on them, collected a premium for it, issued him a deck sheet. Then in August, he sent in an appraisal for the diamond ring, same thing, issued coverage. He had no reason to believe that there was some other ownership proof requirement.
Are you arguing either well, perhaps explicitly, but at least generally, were you and are you arguing that for the insurance company to place a big emphasis on ownership, they should have done it when they wrote the ring onto the policy?
Well, if they had done nothing, they might be in a position to say, here's how ownership must be proven. But after having said, here's what you need to show ownership, you need an appraisal.
In order,
they can't come in later.
Perhaps they argue that, well, that's all that you have to do in order for us to add it to the policy. But if you make a claim, you have to show more.
Well, it's either covered or it's not covered. So if they say, we can place coverage if you do A, B, and C, they can't then say, what's really true is in order to get coverage, it wasn't really covered then.
Yeah.
In order to get coverage, you actually have to do A, B, C, and D.
Yeah.
So I use the words bait and switch, but the terms from the Darner case, which are incorporated into Raji contract number 26, is you may consider, in interpreting, in deciding what the contract provision means, you may consider the surrounding facts and circumstances. To determine what the parties intended, you may consider the acts and statement of the parties themselves before any dispute arose.
Let me make sure I completely understand your argument. The Raji 26 talks about determining what a contract provision means. You have indicated that ownership is implied by law, is not an express contract term. What specific language of the policy did the jury need to interpret?
What ownership? The jury was instructed that we had to show ownership.
Right.
There was a dispute about how you do that.
Fair.
That's a factual dispute. That's what juries are supposed to figure out. What the jury was not given is an instruction that says the representations made by the insurance company before the dispute arose is one of the surrounding circumstances that you can use to decide what that ownership requirement means.
But the ownership requirement isn't a contract, a provision that appears in the express contract. Do you agree?
I agree with that. And that makes it even more important.
Help me understand that.
So ordinarily we say, in a reasonable expectations case like Darner, if you had read the policy, deeply buried in there, you might have found these words, but we all kind of recognize that in these boilerplate contracts that are 25 pages long, nobody's really going to read them. So you're kind of stuck with those words unless somebody told you that you had reason to rely on, that something else was going to be in there. So in the Darner case, he was told you have $100,000 of coverage. He didn't actually check. Turns out he didn't. In our case, it said, in order to get coverage for a diamond ring, you need to give us an appraisal. That's what he was told. Then they told the jury, no, that's not actually how it works. You need to do something else. It's exactly the same legal status as in Darner.
It is unusual, though, isn't it, to be applying Darner and the reasonable expectations doctrine to a word from a statute.
And the reason why I was saying to Judge Tuma it's even more important here is had Mr. Wynn actually pulled the policy out and read it, he never would have found the words, you have to prove ownership. So he had even less of an opportunity to realize that he had been misinformed by the sales agent at the time he applied for coverage for the jewelry.
Counsel, I assume that you argued these points to the jury about the circumstances. Why was the instruction absolutely necessary for you to make your argument?
Your Honor, one of the rules of law that we've cited a case, I forget which case it is, but it's the general rule about jury instruction. If there's a legal theory supported by the facts, then the trial court must instruct. It's one thing for Langerman to turn to the jury and say, here's what I think, and defense counsel gets up and says something totally the opposite, and then the jury goes, well, this lawyer said this. It's very different when the judge says, and the law in the state of Arizona is, and you must do this.
But even if the trial court does commit an error, the error still has to be prejudicial. And if the jury thoroughly understood the point that you were making, and that the court didn't tell them that they couldn't agree with you, then arguably your client wasn't prejudiced. Arguably.
Your Honor, ordinarily, if it was a issue of evidence and we showed error, we'd also have to show prejudice. The rule with regard to jury instructions is you're entitled to the instruction, and if the judge doesn't give it, it is reversible error.
So,
because there's no way we can show what would have happened if the jury had been given the proper instruction that the judge refused to give.
So are you saying that that's structural error, to not giving instruction?
It is reversible error. The
Yeah,
law is very clear.
So we don't like a prejudice at all?
How can we say, here's what the jury would have done if the judge had given them the proper instruction? If you had to prove that, there would never be reversal for failure to give a jury instruction.
Well, and I won't continue this. I just want to be clear. So what you're saying essentially is that the instructional errors are structural error. We don't look at prejudice at all. Is that what you're saying?
That's what, and we cited the standard review case, and it starts with a B, but the name's escaping me now. It's a Court of Appeals case.
Counsel, let me ask you, just on the Raji 26, Contract 26, because I think the parties cite both reasonable expectations cases as well as, and the Raji itself talks about determining the intent of the parties. Your argument is that instruction was required because the jury needed to determine what the parties may have meant or understood the word ownership to mean. Is that fair?
Well,
in other words, it seems to me that's different than reasonable expectations. And I want to make sure I understand your argument because this is the only chance we get to clarify.
the terminology used by the court in Darner is equitable estoppel. But if you reasonably rely on something, you're entitled to have your expectation met. So in the Darner case, as in this case, they represented to Mr. Wynn, here's the steps you need to take in order to get coverage.
And I understand that part of it. It just seems to me reasonable expectation is one party does or says something the other party relies on. You know, there's an equitable aspect. Whereas 26 talks about, hey, how could you have interpreted this language? What does this language mean? And those things, at least in my mind, seem to be somewhat different. And I just want to understand the crux to your argument.
Perhaps they are, and the language from Contract 26 is almost directly from Darner. If you match them up, you'll see they match.
And you were quoting from Darner, and I was reading the Raji, and you're absolutely right.
Right, and I helped write this instruction, so I'm aware of that. And
I understand.
we were entitled to have the jury hear the judge say, so Judge Howe, it was the judge who should have said this, not just me. So I could say it's not just me, the judge said it too. That if the insurance company represents that coverage will be placed based on this, then coverage is placed if we show that. They can't back out of it. That would be the intent of the parties, Judge Duma. And that's where it comes in. And I should have been able to not only argue it, but be able to say the judge agrees with me in essence, or I'm just following what the judge said. I wanted to talk about the evidentiary issues, but I'm going to save my last 3 minutes.
Very well. Thank you. Mr. Perry.
Good morning, Your Honors. My name is Michael Perry. I represent the Applee American Commerce Insurance Company. And I had a little opening statement, which was very pithy, but I'll skip it and just get right to the heart of things. I need to apologize to the court for my lack of thoroughness in writing my answering brief with regard to jury instruction number 4. Because when I sat down to prepare for argument, I went back to my notes from trial, and I noted that when we argued jury instructions in the jury room the night before closing arguments, I argued that the case did not stand for the proposition that it was being cited for.
That's
And
Anderson that you're talking about?
this is the Security Insurance Company versus Anderson case.
Okay.
And the following day, when we made our record, that part of the argument didn't get advanced because the judge was going to deny the instruction, and so I didn't make my record. Mr. Langerman made his record, but in preparing for argument, I went back and I read the case. Surprise, surprise. It doesn't say what Mr. Langerman says it says. The case, in fact, supports the position that ACIC did the appropriate thing here in that they kept the premium for the house coverage, which was in place, and they canceled the policy on the date of non-renewal. And the record is full of evidence that the policy was canceled on the renewal date. The premium that should have been refunded would have been the scheduled items coverage. The problem with that was, as cited in the record, no premium was ever charged to the TAS and Mr. Wynn. That's in testimony J. Studebaker, Exhibit 3 of the log notes on page 2, and Exhibit number 22, the ACIC underwriting file on pages 32, 40, and 41.
Tell me then how as much attention to rescission as I think the record bears snuck into this trial. Because it seemed to me that the trial was in part based on rescission, not cancellation. Now the briefs are, take the sort of tweener view, and you're now telling me consistent with cancellation, but
Yes.
Those are different things to me.
Yes, and had I been paying closer attention at the time that the pretrial statement came over from Mr. Langerman, I wouldn't have, and if I would have drafted the pretrial, I would have drafted it differently. But cancellation is argued throughout the case. And the cancellation not only on the fraud in the application argument, but the cancellation due to the fraud in the presentation of the claim and the lack of ownership of the ring.
Wasn't rescission sort of argued along with that?
It was.
Those joints too?
It was.
Okay.
So
But-
if rescission wasn't eliminated by some pretrial ruling, then why doesn't each side get its requested instruction? One that talks about cancellation, or maybe you don't need it, or why doesn't the other one? Why don't the plaintiffs get rescission?
Your Honor, the reason that they don't get that instruction is that it isn't supported by the case that was cited for it. It is not Arizona law, and I would urge the court to please go back and read the Security Insurance versus Anderson decision, because I was misled when I read the brief, and I don't want the court to be misled. The quotation,
It's not the law that an insurance company seeking to rescind must tender back the premium?
not as is cited in the instruction. And if you read the case, the quotation that's given is actually given, it's in distinguishing the Oklahoma case where the premium needed to be refunded. And in our case here in Arizona, the Anderson decision, as Judge Thumma mentioned, the premium wasn't required to be refunded in order for the company to enforce the exclusion and deny coverage. And the court upheld the denial of coverage, and then it went up to the Supreme Court, and it was reversed on other grounds. But jury instruction number 4 was properly excluded by the judge, and it was not prejudicial error to plaintiffs in the underlying case not to give that instruction.
Was rescission argued in closing on behalf of your client?
Your Honor, I can't remember as I sit here now how it was framed. It is, the closing arguments are an appendix to the,
I had recalled, and I couldn't vouch for this, but they were. And the follow-up question, if they were, is what instruction was the jury given on rescission?
the general instruction was given by the court. I can't remember the number of it right now. I think Mr. Langerman even mentioned it with all the elements of rescission.
The statutory, if I'm
In the
remembering
Raji, Your
correctly.
Honor.
Right, got it, okay.
And that properly covered the issue. let me go to Exhibit 26, also our jury instruction, Raji number 26 also. This is not a case of Darner reasonable expectations. This is not a bait and switch of a car on a car lot. This is an insurance contract, and before there can be a reasonable expectation of coverage, the insured, here the Mr. Nguyen and Ms. Ta, needed to comply with all the terms of and conditions of the policy. One of the things they needed to do was they needed to refrain from making false statements in their application. Number two, they had to, by statute, demonstrate that they had an insurable interest in the ring. And number three, they needed to refrain from fraud and false swearing in the presentation of the claim. And I'm sure if you've read the briefs, you'll see that the record is replete with false swearing by both the plaintiffs in the presentation of the claim. But let me go back to the ownership or the insurable interest issue, which is the heart of Mr. Langeman's argument here. To say that an appraisal is all that's needed to insure something, and after that, carte blanche, you've got coverage no matter what, is simply an invitation to fraud. As the claims vice president, Suzanne Gribb, testified at trial, I could take your watch down to the corner drugstore and get an appraisal from the jeweler there, but that doesn't make it mine. Ownership is not possession. And just because you have something in your hand doesn't mean that you own it. The statute says that you have to own something in order to be able to insure it. And that was one of the arguments, and many hours were spent by experts and otherwise trying to develop facts, first of all, to see if the claim could be supported that they owned the ring. And when that wasn't clear because the documents didn't support it, then developing more evidence that they certainly could not have purchased the ring as they testified under oath that they did. So the court cannot ignore the statute. The statute is a condition of being able to get insurance. And just to say that Darner, reasonable expectations, neener, the agent said all I needed was an appraisal to get coverage. Well, that's only the first part of it. The rest of it is that you have to comply with the terms and conditions of the law and of the policy itself.
Is there anything, did you brief in any way the question of whether Darner could even apply to a definition in a statute?
I did not, Your Honor, and I don't believe Mr. Langeman did either, but I could be mistaken about that. Let me go back and mention one more thing about, I'm sorry to skip back to jury instruction number 4, but if you look in the record, you'll see that we argued very long and very hard a motion for partial summary judgment on the misrepresentation in the application count. That motion for summary judgment was denied, and that was one of the things that Mr. Langeman cited as error in his brief. Well, nowhere in that motion for partial summary judgment is the issue raised that there was no refund of the premium, and so therefore there can be no rescission. It didn't come up until trial. And we see the jury instruction. I was surprised by it. I guess I shouldn't have been given the pretrial, but if it would have been something that was so glaringly obvious, wouldn't it be incumbent upon counsel to raise that at the motion for summary judgment stage, which is on the very same count as the rest of the motion, which is fraud in the application? It wasn't raised.
Well, and I understand that, but it wasn't the intent of that motion to take that away from the jury so you'd never have to deal with those jury instructions.
Yes.
So, I mean, I understand your point, but it seems like instructions would follow that motion, not lead from that motion.
But if it had been the law, wouldn't it have been cited in the motion for summary judgment? Because that would have been a basis to strike it at that point as well, as well as the arguments that exhibit number 25 was not properly in evidence.
Well, and you're referencing 35, right? Exhibit 35.
Yes, I'm sorry, Your Honor,
No,
35.
I just wanted to make sure I didn't
You're right.
inject any confusion to add to what I have. But you're not claiming the rescission issue was waived by the time you got to jury instruction?
No, I'm not, Your Honor. I'm just saying logically,
I
if it
understand.
was really that big of a piece, it would have been mentioned. Let me skip down to the issue of the privilege being waived as to the claim, the entire claims file. Your Honors, Judge Willett initially didn't want to deal with this issue, and so she granted the motion to compel. I filed a motion for reconsideration. It was fully briefed extensively. We were allowed over an hour of oral argument on the issue, and the motion for reconsideration was granted. And she sent it over to Judge Schneider, retired Judge Barry Schneider, who's a former civil presiding judge. And we briefed, he went through the briefs, we argued with him, he went through every page, every line of every document that was in the privilege log. And he ruled that some of those things were admissible and some of those things were not admissible.
Just to clarify, discoverable?
Discoverable.
Okay,
Yes,
thank
I'm
you.
sorry.
No.
That's a key point, Your Honor. I appreciate it. This was a very considered decision. The Lee case was argued up and down, back and forth, and sideways to both Judge Schneider and to Judge Willett. The Lee case does not stand for the proposition that there is never any attorney-client privilege in an insurance bad faith case, which is obviously what Mr. Langerman would like you to determine. The Lee case stands for the proposition that there can be an implied waiver of the attorney-client privilege when the attorney's advice or the attorney's opinions then form the basis for the decisions that are made by the insurance carrier into the denial of the claim. And that is not what happened here. If you look at exhibits,
It's sort of like you arguing that the carrier didn't pay much attention to your advice.
well, Your Honor, ultimately, I didn't give any advice as to whether the claim should be denied or not. If you look at exhibits number 18 and 19, which are the items that were transmitted in the email the day before the roundtable, those are summaries of the financial records.
Those were admitted.
They were admitted into evidence. They were used extensively, not just by us, Your Honor. They were used by the plaintiff and by the plaintiff's expert. In fact, I asked Mr. Strizlik if he had any complaints or disagreements with what was in the summaries, and he said he did not. And those are just factual recapitulations of hundreds of pages of financial documents, dates and balances, what was in the CD accounts, what was in the bank accounts. And there's another reference to an email that Mr. Langerman cites on, I think it's March 26th, where there's a statement made in an email from me to Jay Studebaker that there's a lack of evidence of an insurable interest or an ownership interest. And he gloms onto that and says, aha, that's the advice. That is the nugget that gets us the whole case. Well, all I was doing was stating a fact. At that point, we had an appraisal, which, as I've talked about, doesn't prove ownership. It's one of the indicia of ownership, but it doesn't prove ownership. And an appraisal is something that you would need if you were going to perpetrate insurance fraud. Because if you don't have an appraisal of a $75,000 diamond ring, you're not ever going to be able to get the item scheduled. So it's a necessary part of any fraud to have the appraisal. So the existence of one does not mean that there's ownership. So I was stating a fact that other than the appraisal, there's no bill of sale, there's no receipt. They were refusing to give us any financial documents at that time. On March 26th, they did 2 months later. They gave us all the financial documents, which did not support their claim. They couldn't remember the name of the person that sold them the ring, even though he had made 5 to 7 trips over to California. We couldn't reach that person. He said he had no phone records to reach the guy because he called him on the pay phones, didn't use his cell phone or his home phones. Literally, there was no way for us to find out if they owned the ring or not. All we had was the appraisal and their say-so, which the jury concluded rightfully and correctly was false, was fraudulent. The whole claim was fraudulent. That information, that opinion and the information in those exhibits do not constitute the type of advice or opinion that the Lee case requires for the claims file to be thrown open. And Judge Schneider knew that, Judge Willett knew that. Their rulings were not an abuse of discretion. This is well within their purview as trial court judges to look at the evidence and make a ruling, and that's what they did. And it was a correct ruling.
In making his ruling, did Judge Schneider, as the special master, did he comment on or express legal conclusions regarding whether there had been a waiver of the attorney-client privilege?
Your Honor, he stated in his rulings that several of the items that were in the privilege log were facts that were transmitted to the company, and so therefore they were discoverable, and that they shouldn't be kept from the plaintiffs. But with regard to the ultimate issue of privilege, I don't know that his ruling addressed that. I mean, there was some success had in the review by Mr. Schneider, Judge Schneider, which we had to pay for because it was on motion for consideration, and we offered to have Judge Schneider pay for to pay for his time. But Judge Schneider knows the law on bad faith, and he knows the law on discoverability, and he had the briefs, and they were full of that.
Counsel, can I replay that? It sounds like Judge Schneider, acting as special master, determined whether documents were discoverable or not. He didn't parse it out by saying, well, this was privileged, but the privilege has been waived. This wasn't privileged and is discoverable. It's just, it was two answers: discoverable, not discoverable. That was it.
Yes, Your Honor.
Okay.
Or discoverable with redaction.
Right.
As he did.
But not, this was privileged, but the privilege has been waived. That second aspect was never in his rulings. Is that fair?
Not in his rulings. I think in his discussions with us possibly, but not in his rulings, Your Honor.
I understand.
I have used all my time. Thank you for your attention. I appreciate it.
Thank you, Counsel. Madam Bailiff, refrain for a moment, starting the timer. Mr. Langman, I have a procedural question for you that I didn't want to eat into your time on. The reply with respect to the denial of the motion for summary judgment, it could be read, I think, as withdrawing that argument from your opening brief. I just want to understand if that was your intent or not.
In the reply brief.
In the reply brief.
I believe that Mr. Perry is correct, that it needed to be, there was some procedural problem that we hadn't done, and I don't remember what it is now. So the answer to your question is yes.
It's withdrawn in the reply?
Yes.
Very well. Thank you. Madam Bailiff, thank you.
The last thing Mr. Perry discussed was the attorney-client privilege issue, and Judge Gimmel asked him if he was arguing that the company didn't follow his advice, and Mr. Perry said, I did not give any legal advice. That's what he said today in this courtroom. If he didn't give any legal advice, then there is no attorney-client privilege because it requires giving legal advice, not other communications. So if he was just a factual investigator helping to process the claim, the law is very clear, all of that is discoverable. And in answer to Judge Gimmel's other question, did Judge Schneider rule on waiver? No, he did not. Judge Willett did, and she made all of the legal rulings, and Judge Schneider followed them. And as we pointed out in the brief, Judge Willett was informed by defense counsel before she had read, well, in the absence of having read anything, that they did not rely on advice of counsel. That turned out to be a false statement. When the trial occurred, the guy who made the decision said, I did rely on what Mr. Perry was telling us during the decision meeting.
In terms of law or in terms of the facts that Mr. Perry had summarized?
Both. So they relied on his factual investigation, some of which were the two financial summaries that came into evidence. They also relied on his opinions regarding ownership and proof of ownership, which, again, this was your question, Judge Gimmel. Can Darner apply to a definition in a statute? Well, we're not asking the definition to be changed. The definitions, it's not a definition, it's a statutory requirement, ownership.
Right.
The question in this case was, how do you prove it? And Mr. Perry said, everybody knows an appraisal isn't enough, and that's just an invitation to fraud. If that's their position, that's what they should have told the insured at the time they were applying for coverage. They said just the opposite. They said an appraisal is all you need. He relied on that. The law is very clear that that becomes a factual issue for the jury to consider. And finally, on cancellation and rescission, it was Judge Tuma who asked, did the trial involve rescission? And if you look in our reply brief at page 11, I cite the transcript and the quote of their expert talking about rescission and Mr. Perry's final argument in which he argued rescission. There is no doubt that was an issue. We were entitled to a complete instruction on how the premium refund impacts that.
Well, counsel, it sounds from argument, though, that they want no premiums to be refunded. Is that not correct?
Was that argued?
The argument here today was that there were no premiums that should have been refunded as to the jewelry.
And, Your Honor, as you probably know from your legal career, what lawyers say is an evidence. What the evidence was at trial, and we cited it, Mr. Wynn's testimony, he said, I paid premiums and I didn't get them back. That was evidence to support the jury instruction. We did not have the banking records to show money going in, money going out, but there was evidence to support that, and we cited it in we cited the portions of the record. It was Mr. Wynn's testimony saying they didn't refund my premium.
Thank you.
Thank you. Thank you, counsel. We appreciate your arguments today. We will take this matter under advisement and issue an opinion in due course. Thank you both.
Thank you.
Thank you.
you very much, I
Yeah.
appreciate it.
Thank you.
See why I asked about the pronunciation? You ready?
Whenever this gets shoved in there.
Thank you. Take care.
Bye-bye.
Bye.
You have a problem finding a parking spot?
Because they have all the parking places in St. John's.